Hello, and welcome to Module 11, where we're going to discuss privacy. We will actually be discussing privacy for two modules, but we will start with the Right to Financial Privacy Act. And what is interesting about this is that this is the older privacy law from 1987, and it only applies to the government accessing personal financial information, which gives you a sense of the concern in 1987. It wasn't that your personal information wasn't shared among private parties and businesses, but it was not a concern. What was a concern was the government's access of individuals' financial records. And it's important to keep in mind that the right to privacy is an individual personal right. And the US Supreme Court had held that there is no right to financial privacy in your financial records in a case that involved a bank releasing bank records to the government who was investigating an individual. And the theory goes, and it is still held by some, that the choice to use a bank is a personal choice, and your financial records are actually the bank's business records. And because the individual has chosen to interact with the bank, they have lost the right to privacy. Many of us don't subscribe to that, and that is not necessarily universally held anymore, but that was really the way it was in the absence of a law. And so that's why this law was enacted in 1987, and it governs the disclosure of financial records of a person, and a person is an individual or a small partnership, and it restricts the government. And as recently as 2015, the Sixth Circuit again held that there is no general right to privacy in financial records at a bank. And this was in response to a bank sharing canceled checks with a prosecutor's office. The idea was a canceled check, you write a check, it's in the public domain. It circulates, and you should not expect that to be private. So there are, of course, exceptions, and it says that financial records can be shared with the government if the consumer authorizes it. That is always, we will see in the privacy area, consent, customer authorization. And then we have some sort of legal formal procedures like a subpoena, a warrant, could be administrative or judicial, or a formal written request. And the formal written request is really the heart of the Right to Financial Privacy Act. And what we'll see, it's consistent throughout the privacy laws. It is a notice and a right to object, essentially. And so the federal law provides that if a bank has been requested to disclose individuals' financial records, they must send a notice that says, we've been asked to disclose your records. If you don't think we should, let us know in writing, be prepared to come to court and present your position. And you don't have to get a lawyer, although you may want one. And the key part is that if you do nothing in 10 days or 14 days, 10 days from service or 14 days from mailing, the government will get the records, as will assume your silence meant your consent. And again, we see that in most of the privacy laws. And if you think about human nature, doing nothing is the path of least resistance. And so whatever is the default is what most people are going to do. Most people don't get this kind of a notice, hopefully, but if no action is taken, the records will be shared. Now, there are some exceptions that don't even require the notice. A bank can always disclose records that don't identify the individual. They can always disclose any records to an examiner from any supervisory agency, to the IRS, to a specific federal statute. And then the last one is to legitimate law enforcement inquiries, but then only a limited amount of information, not the actual full records. Now, there continues to be a dispute. What is a legitimate law enforcement inquiry? The question is that just the request by the police? Should you assume it's legitimate, or is a showing required? And the circuit courts have ruled differently on that. So it's a bit of an open question. But we did read a case where someone tried to rely on the right to financial privacy to challenge a bank releasing their financial information. And that was the Adams versus the Board of Governors of the Federal Reserve. And the Federal Reserve had accessed these individual records of Adams on on various occasions of three individuals, but Adams was the main person. And it was all in the context of a transaction that involved a change in control of the Bank of Montana. Now, Adams had claimed that these disclosures were personal, that they were personally investigating him as an individual. But the Federal Reserve Board said, we're the supervisor, as you saw on a few slides back, we can look at anything from anyone. And so that was the question, whether these records were viewed in their supervisory capacity or whether it was a personal investigation. And ultimately, the court said that because the regulators have the right to investigate individuals in the context of a bank change of control, which we talked about under the bank holding company module, that it was perfectly permissible for the regulators to look at these individuals' records, share them with one another, all under their supervisory authority. And so it gives you a sense that even with these legal protections, there are quite a lot of exceptions, and your records may not be as private as you think. And this is a federal statute. It deals with the federal government, but every state has a counterpart, and they typically are very similar, same types of exceptions, same type of notice, and the right to object. And this was the situation that existed for financial privacy until the Gramm-Leach-Bliley Act. And you might recall that we had talked about the Gramm-Leach-Bliley Act in the context of financial holding companies. But oftentimes when you hear the word Gramm-Leach-Bliley or GLBA, really it's the privacy provisions. That is one of the common shorthands for the privacy provisions of the Gramm-Leach-Bliley Act, because it was the first time there was a law at the federal level that regulated the financial records of individuals when they are shared with other private companies. And this was enacted in 1999, and the public was becoming aware that their information was being shared. It wasn't that it wasn't always being shared. The public was just becoming aware of it. And there was maybe more sharing because we see computers starting to be more prevalent. And so the Gramm-Leach-Bliley Act applies to banks, but it applies to financial institutions, which is a broader term that would include brokers and check cashers. It can include financial advisors, all kinds of companies engaged in any business that is related to a financial activity. And it also is a personal right, so it applies to records that are held and maintained for accounts for personal, family, or household purposes. So it's not a business record, it's a financial, personal, individual record that's being protected. And the information that's protected is the non-public personal information. It's called NPI sometimes, which is personally identifiable financial information and any list or group of consumers derived using non-public personal information in a way that is not publicly available. So your reading talked about this, and your reading excerpt was written around the time the law was enacted. And this publicly available has not turned out to be the big loophole that that article would imply, because the main real public financial information is mortgage information. There was a lot of public records on mortgages, but overall, this NPI is very inclusive. So it's not the definition that excludes information. And it's defined in the regulation that accompanies the law as any information that a consumer provides to a bank to obtain a financial product or service. That's everything in the application. Anything resulting from the transactions, which would be payment history on a credit card, what's purchased, really all the records resulting from the transaction, and anything that the bank otherwise obtains from the consumer or about the consumer in connection with providing a financial product or service, which would be credit reports, employment, tax records, So it's really all the information that relates to a financial transaction with the bank. And then, like so many privacy laws, it's a notice requirement. And it provides for an initial notice and an annual notice. And it also groups individuals dealing with banks into customers and consumers. Customers have an ongoing relationship, such as a loan or a deposit account, and consumers have a brief interactions, such as an ATM or a check cashing transaction. And a notice must be given upfront if information is going to be shared, and then annually. And actually, it's for consumers, it's only if information will be shared. For customers, you have to give the notice whether or not information will be shared. And on the Carmen page, there is an FDIC guide that will give you a little bit more information on these groups and how the notices work. And it's also helpful because it really shows the kind of document that a compliance professional would look at when it's trying to build out procedures for the company that it works for. So it's also a good example of a kind of a compliance guide. And the key part is that a bank may not disclose non-public personal information to a non-affiliate, that's an important word, non-affiliated third party, unless the bank has provided the initial privacy notice, the bank has provided an opt-out notice, the consumer has been given a reasonable opportunity to opt out, and the consumer has not opted out. So again, we see notice and a right to opt out. It's generally considered 30 days as reasonable, although that may vary. But what is also important is that a bank may not disclose this to a non-affiliated third party, which means that a bank may disclose things to affiliates without using this procedure. And this might give you a sense of the benefits of a large holding company structure. All the companies in that holding company are affiliates, and this restriction will not apply. Now, the notice is set out in the statute, and it tells the bank that they must explain to the individual the categories of NPI collected, the categories of NPI disclosed, the categories of affiliates and non-affiliates to whom this information is disclosed, other than under the exceptions, that's very important, practices regarding former customers, practices regarding joint marketing, and an explanation of the consumer's right to opt out, including the methods. Then there's any disclosures under the FCRA, which we'll talk about actually in the next module, which deals with disclosures of information among affiliates. So the Gramm-Leach-Bliley Act does not restrict disclosures among affiliates at all. It is the FCRA that does that, or doesn't do it, as we will see. The company's policies and practices around protecting NPI, and a statement that other disclosures are permitted by law. Now, at first, the idea was that customers would choose their financial institutions based on their privacy notices. And so there was not a sample notice. Well, that didn't really pan out, and the notices were long and wordy, and no one was reading them or understanding them. And so more recently, the Gramm-Leach-Bliley Act now has a model notice, which is the safe harbor. And so I want to pull these up. This will take a moment so that we can talk about these different parts and how these notices really interact. I know one of the questions suggested you look at your own privacy policy. So we will share over here. Let's see. Okay. So this is a privacy notice from Union Savings Bank. Union Savings Bank is a small Ohio savings bank that predominantly makes mortgage loans. So what we see here is this whole notice is set out, and some of the areas where the bank can make changes are in the what. There's a long list of the items that can be in this box, but the bank must pick 6. And then we see this statement in this box that says, when you are no longer our customer, we continue to share your information as described in this notice. This is how it complies with what it does with your information once you're no longer a customer. Now, the important part of the notice are these boxes where you can do the yeses and the nos. And the first two are the everyday business purpose of the bank and the marketing purposes of the bank. Every institution, I will tell you, will say yes, because there's no limiting of that sharing. The next one is the joint marketing, and that is when a financial institution jointly markets with another financial institution. This institution doesn't engage in that, so they say no, but there's also no limiting of sharing. So no is always the answer there. Now, in this particular situation, which is not uncommon for a mortgage bank, it's the affiliate's everyday business purpose, the affiliate's everyday business purpose for information about your creditworthiness and for non-affiliates to market to you. None of this is engaged in by this institution, so they say we don't share, which means they don't have to give an opt-out. These last categories are where the opt-out comes into play. So as you can imagine, it's a lot easier if you don't have yeses, you don't have to track the opt-out. These are big compliance issues. But you're also pretty much restricted forever. You have to kind of stick to your policy. Once you issue it, that's what the bank must do. So before these boxes can be filled out, the bank must really determine what they're doing now and what they want to do in the future, because you're really stuck with what you say in these notices. Now there's a second page, and it has to be 2 pages, just like this. Again, who's providing it? What do they do to protect it? Again, this is a clause that comes right out of the model notices. They'll all be the same. How do they collect it? And there's some examples. Again, there's a laundry list in the regulation, and they're to pick 5 here. Why can't I limit? And then it says because federal law only gives you the right to limit certain types of things. And this is basically putting you on notice that there's other sharing going on that you can't prevent. And then it talks about the affiliates and the non-affiliates and the joint marketing, but because this institution doesn't do any of these things, these parts are essentially blank. By contrast, we're going to look at Discover's privacy notice. Now, again, we have the same boxes. We have the same choice of 6, not the same items, but having chosen 6. But then we come to the boxes here and we see more yeses. And so Discover does do joint marketing, but you still can't opt out of it. Discover shares with their affiliates everyday business purposes, but this is information about your transactions and experiences. That would be your purchases and your payment history. They do share with their affiliates, as you see here, but you can't limit that. So that's considered the bank's information. They can share it with their affiliates, and that can't be prevented. Then the second category with the affiliates and the everyday business purpose is information about your creditworthiness. As we will talk about more in the next module, that essentially means your credit report. And that, under the FCRA, you can prevent. So you see it says, can you limit? It says yes. And then it says for affiliates to market to you. Again, this is coming out of the FCRA, but you are permitted to limit that. So there's another yes. And then it's for non-affiliates to market to you. Apparently Discover doesn't do this, so they say we don't share. But because there are some boxes with yeses in the can you limit, they must give you an opt-out. And here they are using a telephone number, and they are giving you 30 days. Now, on the back side, we have similar information, except that because they share with affiliates, they have to give more examples. And because they do joint marketing, they have to give you categories. And then we see on this particular notice, we have some other important information. In Union Savings Bank, which is a pretty local Ohio bank, they didn't get into this, but because Discover operates nationwide, we see that Vermont and California residents get special treatment. And that is because Vermont and California have more restrictive laws. And basically they say, we will not share information that we collect about you with non-affiliates or for joint marketing if you reside in California. And in Vermont, they say we will not disclose information about your creditworthiness to our affiliates, and we will not disclose your information to non-affiliated third parties to market to you unless you authorize us. So as we will see, that's because of the laws in those particular states. And we often see in multi-state privacy notices, these exceptions at the end. So as one of the questions I asked you to look at said, how does this compare to privacy notice you have received? Is your institution more like Discover, or is it Discover, or is it more like Union Savings Bank, or is it Union Savings Bank? So we'll go back to where we were in the PowerPoint. So we were at the content of the notices, and I'm very curious, of course, as to how much notice individuals take of their privacy notices, and I encourage you to share that in the discussion board. But there's a big piece that's not in the notice, and that is the sharing pursuant to the exceptions. And one of the exceptions, it's in 1016.4, these are all in Title 12 of the Code of Federal Regulations, is sharing necessary to effect, administer, or enforce a transaction? And that's really all the sharing that a financial institution does with service providers, to mail the statements or to create the rewards programs, or all the sharing that is necessary to process applications, do all the calculations. None of that is described in the privacy notice, and needless to say, none of that can be opted out. Now, when it's shared under this exception, the service provider can only use your information to do the services they've agreed to do. They can't use it for their own purposes, but it is obviously a lot of sharing that goes on under this exception. There's then another laundry list of kind of various types of sharing, including what we often see is with the consent of the consumer. The consumer consents, sharing can always go on. And in fact, the consent is often built into the application. So if you ever sign a credit application, it's worth reading what's right above your signature, because you may be consenting to additional sharing. And there are other ones that are needed to comply with law and for business purposes, such as to protect against fraud, to resolve disputes, to fiduciaries and representatives of the consumer, any sharing permitted or required by federal or state law, of course, to consumer reporting agencies. Again, if there's a sale, if an entire portfolio or entire business is sold, the purchaser will, of course, get all the information. And then we see other requirements of federal and state law. And so these are not even all of the exceptions, but what you see is there's a great deal of, I don't know if I want to call it holds, but there's a lot of exceptions. There's a lot of exceptions. Let's just leave it with that. One of the interesting parts of the GLBA is that it has very limited preemption. So we've been talking about preemption, but when they enacted this privacy law, the idea was not to preempt state laws. And in fact, the idea was to encourage state laws. And so that really gets to the Vermont and California, the two big states that did enact more restrictive state laws. And in our next module with the FCRA, you'll learn why there probably are not any more of these. And so with that, I think we will finish this privacy discussion, and we'll carry on with the next module. Thank you.